So we wanted to open it up if any members of the public had questions for our panel today.
My name is Jim Dixon. I'm with the Faith Coalition for the Common Good. I'm on the rail task force. And recently, and quite often in fact, the city is using Hansen Engineering to do public meetings and gather input. They just had a meeting about a week ago, and what they did at the end of the meeting, they did not want to take any public comments. They said for people to go to the back of the room and fill out a card with their comment. Since Hansen is acting for the city, can we FOIA Hansen to get the comments from that meeting?
Should I take that one, or? Well, I'll give you. You know, you might get two different answers. Let me give two answers. So first, there could be an argument that Hansen is a subsidiary public body that turns on the relationship between Hansen and the government entity and how much control the government entity has. There's also a provision that doesn't get used quite enough, although for BGA we have some cases that are addressing this, which says if the government contracts a governmental function to a private entity, then those records that relate to that function, those are considered public records. So you would make a FOIA request to the government body that hired Hansen, and you would request those comments, and your position would be that the village or whoever it is required to go to Hansen to get them. It turns on whether that's a governmental function or not, and we don't yet really have a lot of law on what that means. But I think the clearest case would be if the government had been doing it and then contracts it out. Well, it was government before, it's governmental before, and it continues to be governmental after. So I think the law does provide you a way to get at that.
Sort of. I would add this: if any of those cards contained opinions, they could be exempt from disclosure. That's true. If someone said, well, I think this is a bad idea.
I would agree too. I think that at least I would interpret the opinion as being the opinion of the government, not the opinion of members of the public. Yes. Now, there is a different exemption about residents or people that provide comments or complaints, but I don't know that that would apply either. But I agree with your second part of the analysis that it's very possible that if you FOIA the government, if that's a consultant or a contractor, that those records may be subject to FOIA from the government. I'm not sure that the engineering firm would be a public body, though, so probably not. But you know, just from my gut, probably not.
And we're sharing now. My general advice is just ask and see what happens, and we go from there.
Okay. In the back.
Larry Daly, just private citizen. It seems to me like we have a problem with the Attorney General's office representing the state rather than the people. Why don't we have an electable Freedom of Information office and officers so they respond to the people instead of to the state and the agencies that they work for?
Well, I think that kind of goes to my point where I don't think the Attorney General should be involved in the FOIA business. I think that the government needs to pass a law that's clear. I mean, look at some of these simple questions that we've talked about here over the last hour or so. I mean, the law is muddy enough where we can't come up with a thing. And I think we all know a lot about the law. And this last question about, I still don't think that if a card has an opinion on it, that's not a slam dunk that it would be releasable. I think that the government, all it takes to be the Attorney General is a law license. Rod Blagojevich had a law license. And so I think that, you know, our current Attorney General is a good one, but we should write the laws in terms of the long view, and the long view should be a clear law that can be enforced by the courts easily, and instead of the situation we've got now.
I agree with that, with Bruce's comments about sort of the primary role of the courts. I think the idea of an elected official whose sole job is transparency is an interesting issue. It's an interesting idea, because that's what that person's going to be held accountable on, is on that issue and that issue alone, and not that is part of a broader mix. So it's an interesting idea that I'm going to think more about.
Okay.
My name is Vinod Gupta. Which state has the best FOIA law, and what can BGA and other media and other agencies do to make state of Illinois similar law?
Well, my two favorite states are Washington and Florida, neither of which has a role for the Attorney General in the enforcement of the law. Both those laws tend to be fairly short. The thing I like about Washington's law is that the enforcement mechanism is so strict that government has to pay attention to it. They must be transparent. The cost of being transparent is huge, and it's also a mindset. I mean, here in Illinois, people just don't think of things as that should be public as being public. So it's going to require, to some extent, a cultural shift. But Florida and Washington are worth emulating. They're worth taking a look at. Neither state is perfect. No state is perfect. I think, as Andy Shaw started out saying, it's a process. It's a journey that never ends. I mean, there's always going to be a yin and yang, a push and tug. But at the end of the day, the laws that work best are laws with teeth that don't require the government, an elected official or anybody in the government to enforce them.
I would echo that.
Mm-hmm. What kind of enforcement provisions can you talk about? Florida's?
Florida, I'm not as aware of Florida as I am of Washington State. Washington State has a per-day fine, and so there have been judgments as high as $750,000 against government bodies in Washington State. It goes too far in some people's views because inmates now have figured out, hey, you know, rather than sweep the floors, I can make FOIA requests. And in fact, an arsonist, I think, collected $445,000. Those are, again, outlier sorts of things. There's a handout that I put out where it was the state of Washington paid $4.8 million in over 7 years in fines. And that's considered scandalous in the state of Washington. Think what we're paying here to run 10 full-time attorneys in the Attorney General's office, soon to be 15 full-time attorneys. It's going to be a lot more than $5 million over the course of 7 years. And in Washington State, at least, for that $5 million, they got their records. Here, it seems like we get quagmire.
I've got two questions. Julie, how do we obtain information from school board closed sessions? And for the panel, public records, and let's just use the building next door. The folks that work there or are elected into the building next door, if they have civil or criminal records, how can we obtain those?
I could take the civil or criminal. I think you're talking about court records. That's a different bailiwick. That's covered by the Clerk of Courts Act. It's not covered by FOIA at all. And so FOIA is a non sequitur when it comes to court records.
And I'll take the closed session. Right now, all public bodies in the state under the Open Meetings Act have to tape either audio or video. I don't know anyone that videotapes their executive sessions or closed sessions of their meetings. The audio tapes have to be held for 18 months. They're not releasable to the public. They are not disclosable at all. They are secret. They're confidential. So unless a public body releases the audio tapes, they're not releasable. Now, their minutes, the actual formal record minutes of a closed session meeting, they have to do minutes just like they do for the open session. Those are every 6 months, every public body has to review their closed session minutes and decide whether or not they should stay confidential or whether they can be released. And I work with my clients on this all the time. So we will do a semi-annual review, and we'll look at the last 6 months of closed session meeting minutes, and then we'll decide that settled, or that case settled, or that case went to court, or that purchase of property is done, it's closed. Those minutes can now be released to the public, because there's no need for confidentiality anymore. But if there's, let's say, ongoing litigation, so I'm going into closed session, I'm advising the government that, you know, this is what happened in court, this is what we're looking, we're discovery, we're talking settlement, whatever it is, those minutes remain confidential for the length of the litigation, because releasing them could be harmful to the government's strategy in litigation. So if you're asking about closed session minutes that have been released to the public, that's just a FOIA request. If you're asking for closed session minutes for meetings that are still confidential because the issues aren't resolved or they're still ongoing, I don't, you know, there's probably nothing that the government's going to give you at that point.
Follow up then. If it's been released, the situation is over. Mm-hmm. Okay. What if the taped minutes don't really line up with what you're getting on paper as the recorded minutes?
there's not a lot you can do because the minutes are the minutes of whatever board. They're the ones that approve what those minutes say, and the tapes, the statute is very clear that those tapes just are not releasable. Now, if you file a request for review with the public access counselor, with the Attorney General, on an Open Meetings Act, you assume there's a violation. In this case, the minutes have already been released, so your situation, it wouldn't really apply. But if you thought that something, you know, they went into closed session, talked about something that wasn't proper, the Attorney General can listen to the tape as part of the investigation, or a court could listen to the tape. But I don't know that you're ever going to hear the tape. I mean, under the statute, they're just confidential, and then eventually they're just destroyed. The reason that the statute was changed to require the recording was for enforcement of Open Meetings Act. You know, whether you're going in for improper purposes, you're straying, you know, you went in for personnel, you started talking about litigation, whatever it was, really to make sure that the Attorney General and the court could listen to those tapes to see if there was a violation.
I think and I haven't addressed this issue like specifically, but I would think that the court, at least a court, would have the inherent authority to say if you improperly went into closed session that the tape ought to be released. I don't. Maybe there's something that bars.
I believe there's actually been a case here in locally where that's happened.
You know, now that you say that, the Attorney General on a request for review on an improper, and not what you're talking about, which is the minutes maybe don't line up, but on a request for review of you went into executive session for improper purposes or you talked about something else, I think a very recent opinion of the Attorney General said you not only have to release the minutes, but you have to release that portion of the closed session tape. So a portion of it could be released.
And that makes sense because the whole idea is you were never supposed to be in closed session, and if you hadn't done it the wrong way, it would have been out in open session for everybody to hear.
And a little bit of trivia, the father of that ordinance or that statute was Barack Obama.
Is that right?
Yeah, it was. He pushed it through, and now, you know, look what a reputation he's got for open government at the federal level. So.
Which is probably a whole nother discussion for another day.